Good afternoon, everyone, and good morning to those of you on the West Coast. We have a great group of folks gathered here in our Washington, D.C. office, and we have about 3 times as many gathered on the telephone and the web throughout the country today. So we have great participation, over a couple hundred people for today's program. Welcome. My name is Jeff Tenenbaum. I chair the nonprofit organizations practice here at the Venable Law Firm. Welcome to our program today, Understanding Compensable Time Issues for Nonprofits under the Fair Labor Standards Act. As many of you have come to gather recently, this is part of what has quickly become a monthly series, and in fact, in some cases, we're going to be doing more than one a month, series of seminars and webinars on nonprofit legal issues that our nonprofit organizations group has organized. We've done these for several months now, and we're going to continue to do them on a clip of at least once a month. For all of you who are here today or on the phone, you'll continue to get announcements about these programs, so we certainly encourage you to participate. We're trying to hit topics that are hot topics in the nonprofit legal community, topics in which there tends to be a lot of confusion and misunderstanding, both new and developing issues as well as kind of old bread and butter issues that people need a lot of refreshers on, in fact, this being one of those. We're trying to touch a broad array of different topics, everything from employment law to tax exemption to copyrights and trademarks and privacy and everything else under the sun. If you ever have suggestions for particular topics that you'd like us to try to cover in some of these seminars and webinars, certainly feel free to pass those along to me. We're always doing them from 12 to 2 p.m. Eastern Time with lunch served in our D.C. office for those of you who can come, and we always do it with a web component so that people can dial in from across the country. We also record all of these, so for those of you who have colleagues or others who may want to listen and watch the PowerPoint presentation and listen to the recording of these programs, they're all being recorded and they're all available on our firm's website. I'm going to give you, before I forget, 2 links that will make it easy for you to find both the recordings of prior presentations as well as listings of upcoming presentations, as well as a link to kind of an index of what now is probably top 600 or so articles and PowerPoint presentations on every major nonprofit legal topic that you can search by topic area. The first one with the event listings is www.venable.com/nonprofits/events, nonprofits/events. And the listing of all of our publications and articles and PowerPoints is available at venable.com/nonprofits/publications. And for those of you who follow those sites regularly, we are constantly adding new material to both of those. Today's topic is an area that this was actually an issue that I think I wrote, one of my first articles I ever wrote on nonprofit legal issues back when I first started practicing law. And I wrote it at the time because it was an area that I could tell that a lot of folks in the nonprofit community who I was dealing with at the time had a lot of confusion about, and I was confused too when I was initially learning this area. Well, that hasn't changed. In fact, I've gotten a lot of feedback from folks leading up to this program saying, please cover this and please address this. This is such an important area. I get so confused by this. It's an area that it doesn't seem to ever be kind of a hot button issue or something that you read about a lot, but it's such a common, such an important, such a day-to-day issue that you need to be cognizant of, need to understand, and need to address properly because the consequences can be very severe for your nonprofit organization. What we're talking about, of course, today are the rules that govern non-exempt employees. And my colleagues who are going to be our featured speakers today are going to get into this in, of course, a lot more detail. But all employees of nonprofits are either exempt or non-exempt. And my colleague Grace is going to explain a little bit more about what that means. But today's program is not focused on what is the difference between exempt and non-exempt, and are you properly classifying your employees as exempt versus non-exempt. That's a seminar for another day. We did a kind of a companion seminar a couple months ago about the difference between employees and independent contractors, another very important issue. But today's program is focused on, for non-exempt employees, assuming someone is properly categorized as non-exempt. For all non-exempt employees, the law provides under federal law you have to pay overtime at time and a half for all hours worked over 40 in a given week. So it becomes very important to figure out, well, what time are you counting toward those 40-plus hours in a week? And it's not as clear as it might seem. Just because someone has a 9-to-5 work schedule doesn't mean that they're being compensated as a non-exempt employee for 8 hours a day. As you're going to see by the end of this program, it's a hell of a lot more complicated than that, unfortunately. It can be very difficult, very confusing. You need to both understand what the rules are in this area, and you need to implement kind of proactive, preemptive procedures in place to ensure that your non-exempt employees are following those rules, that you don't end up later getting burned by having to compensate folks for hours that truly constitute compensable time when you didn't think it did in the first place. As Grace and Rob will talk about, the consequences for that can be quite severe. Let me talk for a minute about the format here. We have a PowerPoint presentation that Grace and Rob are going to walk you through. In terms of questions, for those of you on the telephone and the web, there's a chat feature that many of you are familiar with where you can pose questions. I'll be monitoring the laptop here at the front of the room. I'll be monitoring those questions. I will kind of synthesize those, simplify them, and pose them to the speakers at certain points throughout the program, and then after Grace finishes speaking and then after Rob finishes speaking. So feel free throughout the program to pose any questions that you have on the chat feature. As you can imagine, some of those questions will end up getting answered just during the course of the prepared presentation, and those that are not, I'll be sure that we get those answered by our speakers. For those of you in the room, while we don't want to disrupt the flow of the presentation too much, if you have kind of an important question that you don't feel is being addressed or is kind of a gap in the presentation, definitely feel free to raise your hand at any time and ask those questions. But otherwise, we will leave time in between, after Grace's presentation and after Rob's, to take questions from those of you here in the room. And then at the end, after Rob is finished, we'll open up the phone lines for any of those of you on the phone who want to ask questions orally. Our two featured speakers today, to my far right, Grace Lee, and to my immediate right, Rob Friedman, both are key members of our labor and employment practice here at Venable. Both do both employment counseling for many of our nonprofit clients as well as for-profit clients, as well as employment litigation. So they understand these issues both kind of at the front end and the back end, trying to help employers figure out what not to do wrong and how to keep them out of trouble, and then of course bailing them out of trouble if they get hit with a lawsuit or an investigation or an enforcement action from a governmental entity later on. They're both very experienced in this area as well as all areas of employment law. I think you're going to really gain a lot of tremendous insights from them today. I'm excited about this program, and with that, I'm going to turn it over to Grace to get us started. Grace?
Thanks, Jeff. Okay. It's not advancing. We're having a little bit of a technical difficulty here. How about if I use a clicker? Yeah, does that work? Oh.
There we go.
Okay, thank you. I guess you have to press it really hard. Well, Jeff gave a good overview already about the topics that we're going to cover today. I'm just going to give you a little bit more background about why we're here. You know, it's 100 degrees outside, and yet you chose to get outside of your air-conditioned office and get on the metro. Hopefully your car was air-conditioned. I did not have that benefit the other day, and it was quite miserable. But you know, this is obviously a very important topic. It's an area where nonprofits have a lot of confusion, and you have a lot of different types of employees at nonprofits that fall under different exceptions and things like that. So again, you know, we're concerned about compensable time because it's one area that employers consistently fail to identify or record or compensate properly for off-the-clock hours spent by employees performing compensable job-related activities. We're going to talk about what that means, but there are a lot of things that your employees do either during travel or at training and meetings and things like that that could be compensable time. They could be coming in early to work, and that's, you know, start working before their shift begins. That's off-the-clock work, and we have to be sure that we are properly tracking and properly compensating non-exempt employees for that work. You know, a third of surveyed employers, respondents indicated that their organizations have been hit with a wage and hour claim in the past year. So it's obviously a high area of likelihood for litigation or potential claims. Today, wage and hour class actions outnumber all other discrimination class actions combined. So, and as you can imagine, a class action is very time-consuming. It is very disruptive. And according to the Department of Labor, more than 80% of employers are out of compliance with federal and state wage and hour laws. And the DOL, the U.S. DOL, is increasing its efforts to enforce all of their wage and hour laws. They're also doing a lot to educate employees, all of your employees included, and do a lot of outreach. There's now an app that you can download to your iPhone where employees can track their time and calculate their overtime. So don't be surprised if someone comes to you with their phone and says, you owe me this much for my overtime worked. And again, the Department of Labor has hired additional auditors, and they have committed to performing a lot more audits this year to make sure that employers are following the rules and compensating employees properly, especially in the area of overtime. So just to give you an overview of what we're going to cover today, we've got off-the-clock work, we're going to cover meals and breaks, we're going to cover waiting time, on-call time, we're going to talk a lot about attendance at lectures and training, compensatory time or comp time. We're going to talk about interns and volunteers, which many of you may have already this summer. Travel time is a huge area of concern, and Rob is going to really focus on that. Inclement weather, and then shutdowns and furloughs, which we've seen a lot of questions in that area in the recent economy. So what is compensable time? Before I get into the nitty-gritty on that, as Jeff mentioned, it's as a threshold matter, we want to make sure that we clarify we're talking about the non-exempt employees. Obviously, we have many employers fail to classify their employees as exempt or non-exempt, or even if they do classify them, they don't classify them properly. So there could be employees who are considered exempt who are not actually exempt. And if you haven't looked at this in a while, if you've had a lot of new hires or changes to your management structure, it's a good time to look at that again. We do have a lot of resources on how to classify employees, whether they fall under the professional or the administrative or the executive exemption. And again, we're not going to go into great detail about that today because we'd be here until 6 o'clock, but that is an important area that you want to look into if you haven't already. A common pitfall for a lot of nonprofits is that, because of cultural or organizational morale issues, everybody's paid a salary. And we don't necessarily have people clocking in and clocking out, and we don't have punch clocks and things like that. We all treat each other as professionals, but not every employee who's paid a salary is exempt. So if you have a non-exempt person who is paid on a salary, you still need to carefully track their time and make sure that if any time worked, if they work any hours over 40 in a work week, that they are paid overtime for those hours in addition to the salary that they are getting. And again, some nonprofits may establish different arrangements with their non-exempt employees, and we're not going to get too much into detail about that, but if you have questions about that, we have resources. So again, if you have a non-exempt employee, first make sure they're properly classified and make sure that you're tracking their hours. And then once you do that and you've identified who your non-exempt employees are, what we need to do is think about, okay, what is the compensable time? What hours are we tracking to see if they need to be paid overtime? And under the FLSA, all time spent by an employee performing activities is potentially work time. So that's work time in the office, that was work time at home, and it depends on whether the employee permitted or allowed the employee to perform the activity. So if the employer permits or allows an employee to work, or it would have found out by looking and lets the employee do it anyway, then that is considered working time. So if you see your non-exempt employee staying past their regular shift night and night again, and they come in at their regular hour, they're taking their meals and breaks, and yet they're there after you leave at 8 o'clock, chances are, I have people here in DC laughing, just hit a nerve. Chances are that employee is working more than 40 hours in their work week, and just because they don't report that time, we've got some employees who are very committed to the cause, they want to do a good job, they're just going to put in the extra hours. Just because they don't report it doesn't mean that you don't have to pay it. If you saw it, or if their supervisor saw it, or you should have known because you have computer log-in, log-out systems, you will be held to paying them overtime. And of course, non-exempt employees must be paid at least a minimum wage for all their time worked, and then overtime for hours worked above 40 in a work week. just to be sure we're all on the same page, a work week for FLSA purposes is 7 consecutive 24-hour days beginning when the employer chooses. So your handbook should have a paragraph in there that defines your work week. It could be different for different employers, but it should be established ahead of time, and it should stay the same over time. So you're not just changing the work week to week to fit your 40 hours and circumvent the overtime rules. You've established what the work week is ahead of time, and within that work week, if they work more than 40 hours, they're getting paid overtime. So again, in order to calculate the amount of money these non-exempt employees should receive, we have to determine what is the number of hours worked, or what's compensable time. Again, this usually requires you to pay for all regular shift work time, so their regular shift, 9 to 5, 9 to 6, whatever it might be, and also for non-productive time. So though it may be irksome to many of you if you see someone reading a book while they're waiting for work to be assigned, or the receptionist, the phone's not ringing much over the summer and they're surfing the web and shopping online and they get a package every day. You still have to compensate them for that time. They are required to sit there during that time, and they're not able to leave and use the time for their own purposes. That is compensable time. It includes work done at home or off-site. As a practical matter, you should try to limit the amount of time that a non-exempt employee works from home, because it's obviously very difficult to track whether they actually did that work or not. But if you've got a non-exempt employee who has a BlackBerry and is checking that BlackBerry at night, or is returning phone calls at night, or returning your emails at night after they've left for the day, that's compensable time, and you should tell that employee to track that time.
And Grace, let me interrupt you. This is Jeff. So we know that some of our clients will purposefully, and even our own law firm follows this practice, will not give most non-exempt employees, a BlackBerry or other PDA to utilize in off hours, except in exceptional circumstances, so that they don't run the risk of having a non-exempt employee do work and have to be compensated for it. And obviously that's the cleanest, simplest, easiest option, is to simply not facilitate kind of off work hours by non-exempt employees, and of course not permit it to occur either. But if in certain situations an employer does want to give a non-exempt employee a BlackBerry to use in off hours, or give remote access to the network from their home computer, what do you suggest in terms of how to regulate that conduct? Do you put specific prohibitions or restrictions on when and how much they can work? Do they have to seek approval from the supervisor first, et cetera?
Yeah, if you do have that situation where you've got a non-exempt employee who has that access or that ability to work from home, you obviously want to have a policy in place. And part of this is going to be telling your supervisor to manage that employee. It is the employer's responsibility to control the work of its employees. So have a policy in place that talks about that it has to be approved ahead of time, or that they have to record that time. You also want to have your supervisor sort of monitor it. So does it seem like they actually did 5 hours of work, or is it really 10 hours of work product and they're only recording 5, or vice versa, they've recorded 5 but they've only worked 1. So that supervisor, you're going to have to work closely with that supervisor to monitor and enforce any policies that you put in place. And again, you can't accept the work of the non-exempt employee without counting that time when computing their pay and their overtime. It's really nice that they've given 110%. We're really grateful for it. Well, that's great. You still have to pay for that time. And if you have a policy in place and the employee is supposed to get approval from a supervisor before they work from home or before they work overtime, and they don't get that supervisor approval, you still have to pay for that time. It still counts as overtime worked if it's over 40 in a work week. So unauthorized overtime must still be counted as time worked. It must be paid as overtime. It can be handled as a disciplinary matter if someone continues to do it even after you've told them, look, you can't work overtime unless you have your supervisor's authorization. But it's still, if they do it and we know about it, we have to pay for that time. So many organizations experience or have trouble with off-the-clock work. So, for example, if an employee is coming in early or staying late to finish work, they must be compensated for those hours provided that we knew or should have known that the employee was working. So for example, pre-shift time, setting up an equipment. The employee doesn't really start, the shift doesn't start until 9 o'clock, but they come at 8:30 every morning because they want to get the coffee set up and the copy machines warmed up, and they're going around the office making sure that everything's good to go for the shift, for when the shift begins. That is pre-shift time, and it's a lot of times not counted towards hours worked. It's a common pitfall, so you want to make sure that if someone's coming in early or staying late, that you're telling that person to record their time and that they're being paid for that time. Post-shift time, dropping off mail, hey, take this package on your way out, or other work-related activities after the shift ends is still considered compensable time. And again, if they do work unauthorized overtime, you still have to pay for those overtime hours worked. Meal periods, a lunch break, half an hour snack break, that is not work time, and you do not need to compensate for that time. It usually doesn't include just a coffee break or, I'm going to take a walk and get a snack for 5 minutes. That's still compensable. So a bona fide meal period is one where the employee is completely relieved from duty for the purpose of eating a regular meal, and it usually has to be 30 minutes or longer in order to be a bona fide meal period. And it's not necessary that the employee be allowed to leave the premises. Let's say you just want to keep them close by because something might come up, but they have to be completely freed from duties. So let's say you give someone a 30-minute lunch, and yet 15 minutes into their lunch, you call them back and say, hey, I really need your help with this. Can you come back to work? That is no longer a duty-free lunch, and they have to be paid for that time worked. So even if the employee is, not active while they're eating, if they're not relieved of their duties, that's compensable time. So, someone's required to eat at his desk and stand by for a call. Let's say that call never comes in, but they're required to sit there and stand by for that call. That is compensable time. Again, a rest period, a short duration, 5 to 20 minutes. Those are very common, and they promote efficiency. Those are customarily paid for, and they're not considered a bona fide meal period. Let's talk about waiting times. Yep, we have a question here in DC.
What about smokers that take multiple breaks?
Be sure to repeat the question.
So the question for those of you on the phone is, what about smokers who take multiple breaks throughout the day to go outside to smoke a cigarette? Again, usually if it's not a 30-minute block of time where you've established that the employee is relieved from their duties, then it's compensable time. That's probably going to be akin to a short snack break or a break just to stretch their legs. If it becomes excessive and you feel like it's interfering with their productivity, that becomes more of a disciplinary issue. And you can sort of talk to the employee and say, look, you're spending way too much time at your desk away from your desk. It's similar to, someone is supposed to be working and you see that they have work to do, they're not waiting for time, and you see that they're simply not doing their work and surfing the internet or they're on Facebook all day, which is a totally other topic, which we won't get into too much. That is a disciplinary issue. They're still being compensated for their time, but we're concerned about how they're using their time and their productivity. And again, you want to work closely with your managers to supervise their non-exempt employees and monitor that type of non-productive time. Okay, so again, there's compensable waiting time, and then there's time that's waiting time that's off duty that's not compensable. So when it's compensable waiting time, the employee is not able to use the time effectively for his or her own purpose. The time is controlled and belongs to the employer. So again, you've told them, look, you need to sit here and wait for a call. They're not able to leave. They can't use their time for their own purposes. That is compensable waiting time. If you relieve an employee from duty and they're able to use their time for their own purposes, and they're told in advance that they can leave the job, they're free from duties, and they can come back at a specified hour, then they're off duty, and that is not compensable time. So, example, an assistant who's reading a book while waiting for an assignment, that's compensable time. It's their normal work shift. They're sitting there, nothing to do. They're waiting. That's compensable. Time spent waiting for a computer or equipment to be repaired so that work can resume. We don't know exactly when that equipment's going to be repaired. It always takes longer than you think it's going to take. That, again, is compensable time because they're waiting for that work to resume. Did you have a question here?
What happens with a driver who's on an overnight trip? He's away from his home. It's his time, but nevertheless, he can't do his own personal, he can't cut his lawn.
Right, so the question is, what happens with a driver who's on an overnight trip, who can't, use their time to do their house things, like cut their lawn and things like that? We're going to actually talk about that in great detail when Rob takes over in the second half of this presentation, so I'm going to let him cover that in that portion. And if we don't answer your question at the end of that, please let us know. Okay.
Grace, I do have kind of a follow-up to one thing you said. We've gotten a couple questions on the webcast from this. A couple of people asking about kind of de minimis time working from home, that if someone is just occasionally checking their BlackBerry and spends 5 or 10 minutes responding to emails, their supervisor knows they're doing this, but it truly is a minimal amount of time worked each evening. Is that compensable?
It's technically still compensable. There's no distinction for de minimis versus non-de minimis, and I think the risk is you have to weigh the risk. Let's say it's de minimis, 5 or 10 minutes every night, but that adds up, right? And that adds up over the course of a week, it adds up over the course of a month, and if that is not compensated and paid as overtime, maybe you'll be fine, but if that employee gets disgruntled, that is the first thing that they're going to say, hey, they knew, you can see in these emails, I was working from home. And in addition to these emails, suddenly, they're saying that they would do additional work from home, and that is a great risk to run. So I would just include that time as compensable time, and technically is compensable time. Question in here?
You brought up the term risk several times. If someone does not discipline a non-exempt staff for unauthorized overtime, are they running a greater risk if there is eventually a lawsuit from any number of different staff who are doing the same thing and saying the employer must have known because they knew about this one employee, they worked unauthorized and they weren't disciplined. So should the employer take disciplinary action whenever there is unauthorized work done that's overtime by a non-exempt staff?
So the question is, I raised the word risk several times. The question is, should the employer discipline an employee for working unauthorized overtime, and is there a risk of not doing that? Because if you have many different employees, non-exempt employees that are working overtime that you're not disciplining, then certainly that does run the risk of, once you have one employee who brings that up, a lot of your organizations are small, word gets around, and you run the risk of other employees saying, hey, I worked overtime too. My supervisor never said anything, and yet you have policies in place that say that they're not supposed to be working that unauthorized overtime. Again, they need to be paid for that overtime, and so if they're being paid for that unauthorized time, your risk is really lower because you're not going to be hit for back wages and penalties, and then it's more of a risk of you're not enforcing your own policies. We have another question here.
Back to waiting time. What about when the power goes out? Not that that ever happens. But should the power go out and the afternoon is lost, maybe the building is not even up the next day, but someone has to be at work at 9 o'clock. What's concerned?
So the question is, let's say the power goes out in the building and everybody, has to basically stop work. You lose an entire afternoon, but yet it's assumed that you're going to work the next day starting at 9 o'clock. If everybody is relieved from duty and told, it depends on how it's communicated and what the expectations are. If you're relieved from duty when the power goes out and people are told, look, we don't know when this is going to come back up, they're telling us it's going to take a while, you can leave. That's not compensable time. They have been freed from duty. They can use their time for their own purposes. If they are told, you need to wait here until we figure out what's going on with this power, that is compensable time. You haven't relieved them for duty. They can't use their time for their own purposes. More often than not, you're going to have them wait for an hour, realize this power is not coming back on today, so you're going to pay for that hour of waiting time, and then they're relieved from duty for the rest of the day, and that is not compensable time. And then they can just resume their normal work shift the next day.
But suppose they don't make the 40 hours this week, that
So the follow-up question is, suppose they don't make the 40 hours that week that they're supposed to be paid for. And I am assuming in that question that the person is paid a fixed salary every week, assuming that they're working 40 hours a week. Is that?
Yes.
Okay. Yes. So here's the situation with paying a non-exempt employee a salary, a weekly salary. A lot of people do this because, it gives the employee peace of mind. They know what they're going to get paid every week. It's better for your budget. You kind of know what's going out every week. But the risk of that is that, if they work less than 40 hours a week and you don't have anything established ahead of time that says if you work less than 40 hours a week, we're only going to pay you for the time that you worked, you still owe them that 40 hours of salary. And that is a problem that comes up when you've got this established salary for a non-exempt employee. A different way to do it is to pay them strictly for every hour worked. That's a cleaner way to do it. Just pay them for every hour worked. And so that waiting time, that afternoon that they lost, you're not paying them for that time, and you only pay for the 36 hours that they worked that week.
But Grace, here's a follow-up. So say in that scenario, and someone loses, a half day because the power goes out, or a fire drill in the building that they can't resolve. Can you require that person to then work, so say they worked 4 less hours that day than they would typically have. Can you require them to work 4 additional hours the next day, or 2 additional hours each in the next 2 days to make up for that?
Sure, you can do that. Again, you probably want to think about this ahead of time, see what's in your policies. But yes, you can have that employee work additional hours the following 3 days or the following 2 days to make up for that time, as long as they're still not working more than 40 hours in a work week. Some states have a daily overtime rate, so if they work more than a certain number of hours per day, that triggers overtime. But under the Federal Department of Labor standards, you can, as long as it's up to 40 hours in a work week, you can have them work additional hours of remaining days.
There is another follow-up question on the webcast kind of related to this. If the office is closed due to inclement weather and no one's able to come into the office, but the employer would like everyone to work from home that day to the extent possible. However, only exempt employees, because of the system that's set up, have remote access from home. The non-exempt employees don't. Obviously, the non-exempt employees can't work from home. The question is, are they required to either take vacation time for that time, or are they required to not be paid for that time? Obviously, this relates back to your question of whether they're paid on a salaried or an hourly basis.
Right. So inclement weather is a topic that Rob is going to cover in great detail again in the second half. But since it's come up, an employer, a non-exempt employee who is unable to work from home and can't come into the office because of weather has not performed work that day and is not compensated for that time. Whether or not you can make them use their vacation time varies by state. So some states say you can require the non-exempt employee to use their PTO because they weren't able to come into work that day because of inclement weather. Other states say, no, you can't require them to use their PTO. So that's a really state-specific question. Again, if you've got an employee who's non-exempt and yet paid on a salary, so the agreement is you're paid the same no matter what, then you really need to look at what the agreement you've entered into with that employee in your policies to see whether or not they should still be paid for that time even though they haven't performed any work. Okay. Let's talk a little bit about on-call time. So again, if the employee is on call, they are, sort of on standby, they're required to remain on the premises or really, really close so they can't use their time effectively for their own purposes. That's compensable time. You still have to pay for that time. Even if they're not really doing any productive work during that time, they're on call and they are required to be paid. Non-compensable on-call time, an employee is not required to remain on the premises and just needs to tell the employer, where they can be reached. That's not compensable. So if you're, at your annual convention and you've got someone on call to sort of help take down a meeting room when you're done, they're free to do whatever they want, and you know that you can reach them on their cell phone, and when you call them, they're going to come back and help you when the meeting is done. That's not compensable. They are free to do whatever they want until you call them and they come back on duty. Attendance at lectures and meetings and training programs. I know that a lot of questions about attendance in lectures come up, especially with respect to travel time and when you're going to the lecture, when you're coming home from the lecture. And again, Rob is going to cover that. But I just want to talk a little bit about, the actual time spent at the lecture or the meeting. Those lectures, meetings, training programs, continuing education are not working time only if the following criteria are met. The attendance is outside of the employee's regular working hours. Attendance is voluntary. The course, lecture, or meeting is not directly related to the employee's job, and the employee does not perform any productive work during such attendance. So if all of those 4 criteria are met, then it's not working time. You don't have to compensate a non-exempt employee to attend a meeting. More often than not, it's going to be a mandatory training or a mandatory lecture that you want people to go to, and if that's the case, that's compensable time, and you need to pay. Even if it happens after their normal shift, then that's now paid as overtime. Yes, quick question.
Does the determination of whether it's voluntary or mandatory have any bearing on whether the employer pays for it? Would it be voluntary and the employer still pays for it?
So the question is, can an attendance at a lecture or meeting be voluntary, yet the employer still pays for it? And those are 2 separate questions. Those 2 separate issues. If someone says to you, look, I really want to start taking classes at night to get, certification. I'm in IT, but I want to switch to HR, and I'm going to get, take classes on that at night. And you've got a policy that, tuition assistance, and you say, look, I'll pay for a certain amount of your hours. Here's the parameters around that. That's okay, but that time spent in those classes or those trainings is still voluntary, and it's not compensable because, again, it's happening outside of working hours. It's not directly related to the employee's job. Oh, look, it's even one of my examples. And even if the course incidentally improves the employee's skills in doing his or her own job, they've got some great organizational skills now, better communication skills, that's still it's still non-compensatory, even if you are in fact reimbursing the person for that, for the cost of the training or the CLE or the class. So again, independent training, college courses, not compensable time. If the employer, if you as an organization offer a lecture or a training session for the benefit of your employees, but it's voluntary attendance outside of work hours, even if it's job-related or paid by the employer, it's not hours worked. So let's say you've got a great connection, and you bring in a speaker, for someone who just wrote a book, and it's just offered to your employees, 7 o'clock on a Wednesday night. You can come if you want. It's pertinent to our industry, but if you don't want to, you don't have to be there. The employer has paid for the speaker, has provided the room, everything else, and yet it's completely voluntary. So if someone goes, they're not required to be compensated for that time.
Okay. But of course, and I'm getting ahead on your on your slides here. I think it's on your next slide. There is a difference between someone saying, "Well, you're not required to attend, but I'd really appreciate it. It would really look good. It would really help you if you were to attend, this particular training program, or this dinner, or this reception, or this happy hour."
Absolutely. It's a very fine line, and I would say the least risky course of action is to simply pay the person for the 2 hours of that lecture, because, of course, the employee, it's very fact-specific, and the employee could always turn around and say, look, my supervisor basically came to my office, closed the door, and told me that if I'm not there, it's going to have bad repercussions for me and that I better be there. And I didn't say anything about it at the time because I was a happy employee, but now that you're firing me, let me talk about that and all the other times that I've worked off the clock.
Yeah, you laugh, but that's exactly what happens, and that's usually when this stuff comes up. It's not when you're a happy employee. It's when you're a disgruntled employee or a fired employee, and you go and consult an employment lawyer, and they start to ask you a series of questions. One of which is, are you a non-exempt employee? What hours were you paid for, not paid for? Did you keep track of this stuff? That's where the troubles really begin. And one of you guys, Grace or Rob, will be talking about some of the penalties for what happens if you fail to do this stuff properly.
So this also comes up a lot at meetings and conventions. A lot of things come up at meetings and conventions, from what I can gather. So just as a baseline, non-exempt employees have to be compensated for all hours worked at an organization's meeting or convention. So if they're there, they're working, at the booth, they're setting up a meeting, they're presenting, they're talking to people, they are working, that time is compensable time, fine. But what about attendance at a meal during a conference? You know, they're away from their home, and so you invite them to come to dinner with some members after their sort of work shift has ended at the convention. And attendance is purely voluntary. You can come if you want. If you want to make plans with you've got friends in town, you can go see them, that's fine, no big deal. If it's purely voluntary, if attendance is purely voluntary, then that's not compensable time. But again, this raises that same issue of that gray area. When is it purely voluntary and when was it kind of coerced? You know, the employee can't be led to believe that non-attendance would adversely affect his or her employment. You know, they shouldn't be told things like, oh, but these are really important members that would be great for you to meet for your committee work that you're doing. Why don't you just try to come? That's where you get into trouble. So again, least risky course of action, pay for the time, or make sure that you can really prove that it was purely voluntary. Free time spent at the hotel is not compensable time, even though the employee is only there because of association's business. All right, we're going to talk about compensatory time, not compensable time, but compensatory time. It's often referred to as comp time. A lot of employers use this regularly for exempt employees, and that can be done without restriction, but you want to make sure you've got a good policy that clearly spells out how exempt employees can use comp time. That is, here you've worked really hard, you worked 60 hours last week, take some time off the following week, or bank it and use that time whenever you want as comp time. That's for exempt employees. For non-exempt employees, you have to be very, very careful in the area of comp time if it's offered in lieu of monetary pay for overtime worked. So in general, non-exempt employees have to be paid for overtime worked, except comp time can be used in 1 week to overset overtime work that was worked in another week, as long as it's in the same pay period. And as long as that time is calculated at 1 time and a half. We're going to go through an example of each of these. Or you can use comp time for a non-exempt employee if it's used in a single work week to prevent an employee from working more than 40 hours in the work week. So an example of comp time used in a single pay period. I'm just going to run through the examples and then I'll get to your question. Is that okay? So a non-exempt employee works 50 hours during the week of the association's annual conference. The following week falls within the same pay period. The association can require the employee to take 15 hours of comp time, and that's time and a half of the hours worked over 40 during the following work week. That's not within any 2-week period. That's only if it's the same pay period, which should be pre-established through your payroll services and in your policies. So, if in week 1 of the pay period the employee already worked 40 hours and week 2 is the conference and they work 50 hours, they're getting paid overtime for that 10 hours. So that's how you can do it in a single pay period. Within a single work week, an employee who normally works 8 hours per day, Monday through Friday, works 10 hours per day, Monday through Thursday. So they've already worked 40 hours that work week. The employee may use comp time on Friday to avoid working overtime during that work week. And that's a tool that you can use to avoid overtime being worked by your non-exempt employees, and it needs to be carefully discussed with your supervisors. So some tips on the comp time. You should be very clear to explain this in your policies if you're going to allow comp time for exempt or non-exempt employees, and closely manage it in a consistent manner. So you're not just giving comp time to some employees because they've got a really important wedding, but not to other employees because you don't believe that reason is legitimate. I mean, you've really got to set some consistency around how to use comp time. You should require advance approval of the supervisor, so the employee can't just say, I've reached 40 hours, I'm done for this week, goodbye. No, I mean, the employer has to the employer and the supervisor have to have an agreement ahead of time that this week you're working 10 hours Monday through Thursday, and then you're taking Friday off to take a 3-day weekend. And it should be tracked very carefully and recorded on timesheets or other records. This is an area where people get into trouble. We have a question in the back. The question is, what if they don't take the comp time during the pay period that you've asked them to take it and they want to take it in the next pay period? That you can't, if they don't take the comp time and they go ahead and work more than 40 hours and you approve it, even if you don't approve it, that's compensable time. You're going to pay them overtime. And they cannot use that comp time later in the next pay period. It's not banked. For exempt employees, a little different. For non-exempt employees, it has to occur within the same pay period. Okay?
So does everyone understand this? This is a very commonly confused area. People get confused between the comp time rules for exempt versus non-exempt employees. But basically, with exempt employees, you can pretty much do, for the most part, whatever you want. You want to do it in a consistent manner so you avoid discrimination claims and things like that. But for non-exempt employees, it's a very narrow exception, or kind of two exceptions if you want to think of it like that. I like to think of it as one. The one exception that Grace explained where you can, if it's in the same pay period, so obviously this argues for having at least a 2-week pay period as opposed to a 1 week. It gives you more flexibility, especially for nonprofits that hold on meetings and conferences where you have excessive hours in a given particular week. So you can do it within that same pay period, but it has to be at time and a half. That's the only way you can do comp time for non-exempt employees. The other example that Grace referred to about kind of using it in a single work week, I kind of view that more as simply regulating hours worked. That in whatever given work week, you can regulate and say, in this particular week, you're going to work those 40 hours, Monday through Thursday, and then you're not going to work at all on Friday. We did have a related question earlier on the webcast. We're not completely related, but a lot of employers have a work week, an official work week that's less than 40 hours. The example posed was 37.5 hours. So if an employer has an official 37.5-hour work week, the question was, does overtime have to be paid for every hour over 37.5 in a given week, or only over 40?
Over 40 hours in a work week. You still pay overtime over 40 hours in a work week. That's more of an internal policy to sort of set your employee schedules and things like that. But a work week is really a 7-day period. So it's, even if employees are only working, scheduled to work, or your office is only open 37.5 hours in a given week, that's not necessarily your work week. Those are your core business hours. A work week is, Monday to Sunday is the work week, and all the time worked in that period of time is calculated to see whether you've worked overtime. And the overtime standard is still over 40 hours in a work week, even if you have a 37.5-hour regular working week for your employees.
Right. So if an employee works 39 hours in a given week, even though that's more than the typical official work week, there's no overtime that has to be paid.
That's correct.
Right. And we
straight time.
And we have another question, and I'm not sure I completely understand the question, but it has to do with flex time. And I'm sure you're very familiar with this term, although I'm not sure it's a defined legal term. I would assume that any kind of flex time arrangements for non-exempt employees have to fall within these same basic parameters. There's no exception or other rules for any other kind of flex time arrangement where you give people flexible working hours. You still have the same basic requirements that if it's within a given week, as long as the hours don't go over 40, you don't have to pay overtime, and you can regulate it in that way and give people the option of working more one day and less another day, but that's within a given week. And if you want to spread it over a 2-week period that's within the same pay period, you can do that, but if someone's working, in fact, over 40 hours that first week, then they have to be given comp time at time and a half for the following week. You can't just use the straight flex time hours within that 2-week pay period.
That's right. So it's not just, hey, work 80 hours over the next 2 weeks whenever you want. You have to be very careful about how you do it. And even if it's a flex time policy where it's not, you have to be in exactly at 9 and you're leaving exactly at 5, some days you can come in at 10 and, work till 6, or, however you want to set it up. That's an internal policy that you want to make sure that you're managing internally, but the same principles do apply, that if they're working over 40 hours in that work week, and they're not taking comp time the next week at time and a half, then you've got to pay that as overtime. Do we have a question?
Yeah. I recently worked with personnel at the U.S., and they said that for any organization other than the government, that comp time wasn't legal. So my question is that accurate?
Right. So for comp time was originally created for government, the state and federal governments and government agencies, and the comp time that non-exempt employees are able to use in those agencies is different than what we're talking about here. What we're talking about is very limited exceptions to where a non-exempt private employer, non-governmental, can use comp time, and it's very limited. It's very it can be confusing. So in general, yeah, comp time can only be used by government authority, government employers, but there are these two very limited exceptions. Okay? Quick question?
Grace, I have a quick question up on the screen, and I'm not sure if Robert would cover it. Non-exempt recent college graduates that are working in inner-city charter or public schools and work side by side with hourly unionized teachers. If first-year teachers voluntarily attend unpaid training, they come earlier in the school day and leave later, work at home, and their compensation is determined by the 37 and a half hour work week multiplied by the minimum wage either in Maryland or in D.C. But they're working more, and is that a problem in that it is charitable or civic work, or is there no exception for that type of?
There are some exceptions. We're about to go through all of that.
Yeah, I was going to say let's let Rob's going to cover that. And also, I wasn't clear if that was a governmental employer, in which case, as Grace has said, the rules are different. So just to repeat that governmental issue, because it came up a few times in the webcast questions, the rules for government employees with respect non-exempt employees with respect to comp time are very different, and that's not what we're covering here today. We are only covering the rules for private nonprofit organizations. And like Grace said, so that basic kind of statement that people have come to believe over time that for non-exempt employees, comp time is only available for government workers, not non-government workers. Pretty much it's generally true with this one kind of limited exception for comp time within the same pay period. All right, let's move on because we're going to leave Rob with very little time here.
Okay. Time spent performing civic and charitable work. So an employee can spend work for charitable purposes at the employer's request or under their direction or control, but if it is directed by the employer, required to be there, it's working time. If it's voluntary, if it's purely voluntary, I'm going to go on Saturday morning and volunteer at the soup kitchen, it has nothing to do with my job, that's not compensable time. Let's say it's, employer organized, employer sponsored and organized, and yet attendance is voluntary, and again, we have that, is there coercion, is there not? If it's purely voluntary, then and it's outside of working hours, then that, time spent doing other civic and charitable work is not compensable time. We're going to talk a little bit about volunteers. So under the FLSA, an individual is a volunteer if they don't receive any compensation other than maybe a nominal fee or for their expenses to perform the services, and those services are not the same type of service for which the employee is employed. So a current employee of yours can decide or volunteer to do something, at your annual event. It's not required, it has nothing to do with their job, it's not similar to their regular job duties, and there's no expectation of compensation for that time, and it's outside of working hours, then yes, that can be voluntary time for nonprofits, for charitable purposes, and you don't have to compensate them for that time. But you want to make clear that there's a clear understanding that the individual would not be paid for those services. So it's very clear up front there's no expectation of payment, and that it's clear that the individual offered their services freely without coercion. They weren't required to do it. It wasn't like everybody's going to sign up for a shift. Come on, sign up. No, it was purely a voluntary thing. Okay, Rob's going to talk about interns, so I'm going to and travel time and some other issues. So I'm going to turn it over to Rob.
And even though it's not part of our formal presentation, Rob's also going to briefly discuss some of the penalties for what happens if you fail to calculate compensable time properly.
Sure, and I might as well just go through that now just so it's clear to everyone. Well, first of all, good afternoon to everybody, and to our friends on the West Coast, good morning. It's important what Grace is talking about in this session generally. It's not just an academic exercise. The Department of Labor takes very seriously wage and hour violations. And the risk to an employer is great if there are violations in the workplace, because you could face an enforcement action both from the Department of Labor, which is very intrusive, and they'll scrutinize every aspect of your workplace, and you could be subject up to $10,000 in civil penalties from the government. And it's also a very frequent target of plaintiff's attorneys, both on an individual basis and on a class-wide basis. So if you have one non-exempt employee, for example, who may not be being paid properly, and that individual is disgruntled and sees a plaintiff's attorney, you better be sure that that plaintiff's attorney is going to be looking for other employees in the workplace who may be similarly situated, who also may be not properly compensated. And the last thing I'm sure all of you want is to face a class action for wage and hour violations, because they can be very expensive. So again, take seriously what your policies are, and also think about the responsibility of your supervisors and your managers to control the hours of your non-exempt employees, and making sure that the level of supervision is very clear and that you're scrutinizing this. Yes?
If you are receiving a significant amount of federal grants and you are found in violation by the Department of Labor, can this affect your ability to continue to receive federal funding because you were shown to be in violation of Fair Labor Standards Act? Was that completely separate? I'm worried about debarment or suspension.
Yeah, the question has to do with if you're receiving a federal grant or contract and you're found, by the U.S. Department of Labor to have an FLSA violation, you're not properly, compensating your employees properly. Can there be consequences to that under the federal grant or contract? And certainly there could be, particularly if it's a situation where you were overbilling the government. Here in these kinds of examples, it's more likely that you were underbilling the government, but that still could get you in trouble. But it's going to be very specific to the terms of that particular federal grant or contract. That's a bit outside the scope of this presentation, though. And if I can ask everyone to try to, if you have a question, a kind of a burning question that's clearly not being addressed, please pose it. But otherwise, I think a lot of your questions are going to be answered by Rob's presentation. We really want to get through some of the stuff on interns and travel time, because it's some really important stuff.
Right. So a big topic is interns. And as most people in Washington know and across the country, it's intern season. We're really in the midst of it now. And one thing that I'll just want to stress at the outset is, as nonprofit organizations, you really want to pay very close attention to the evolving standards that the Department of Labor is going through right now when it comes to interns. Last year, they issued guidance with respect to for-profit organizations, for-profit companies, and how they should treat interns. And there's a little bit of a footnote, I'm not sure if any of you have reviewed it, where they carve out a slight exception for nonprofits, but they say, stay tuned because we'll be issuing more guidance soon. So what I'm going to go through now when I talk about interns is the general test and the general policy with respect to for-profit companies. But it's very important that all of you pay attention to this, because as you're crafting your internship programs, you really want to make them as consistent as you can with these guidelines, because you will be scrutinized. You're not immune from scrutiny by the Department of Labor just because you're a nonprofit. So keep that in mind, and also stay tuned both to our alerts that Venable publishes and also generally news that comes out, because you're likely to see more guidance in the next year or two. And of course, this is an understandable feature of a down economy, right? You have a lot of employees who are out of work that are looking to fill their resume gaps, and so they're taking internships, sometimes without pay, in order to gain experience and build their resume. So what you're having is a lot of employers are employing folks, and they're kind of crossing the line a little bit between an internship and maybe a position that looks very similar to what their employees are actually doing, sometimes to cut costs, sometimes to downsize, for whatever reason it might be. So the Supreme Court focused initially, when they first came out with guidance about training and interns, on the economic reality of the situation, and asked whether it provided a direct and immediate advantage to the employer, and whether the program compensated the interns to determine whether the employee was a trainee. Shortly after the Supreme Court came down with this initial guidance, the Department of Labor issued a 6-part test that you should look to, as I said, when you're crafting your internship programs, and these should sort of serve as a benchmark or as a guidepost for you to use, because you don't want to depart too much from these, because then you'll be subject to scrutiny by the Department of Labor. The first is that the internship, even though it includes actual operation of the employer facilities, is similar to training given in an educational environment. And you may ask yourself, what is training similar to an educational environment? Well, that's, in general, the more your internship program is structured like a classroom or an academic experience, as opposed to your employer's actual operations, the more likely it's going to be considered to be similar to an educational environment. The second factor is the internship experience is for the benefit of the intern. right? You want the program to be beneficial to your interns and them to be able to walk away with some tangible skills. The third is that the intern does not displace regular employees, but works closely under the supervision of existing staff. And that is, I think, the most critical factor in this analysis. It's because you don't want to substitute your regular workers or to augment your existing workforce with an intern. That's a red flag, a big red flag. So keep in mind that you can't, just to save costs, substitute an employee with an intern in your regular operations. The next factor is that the employer provides the training derives no immediate advantage from the activities of the intern, and on occasion its operations may actually be impeded. The fifth factor is that an intern is not necessarily entitled to a job at the conclusion of the internship. What does job entitlement mean? Well, there's a couple ways to look at this, and I would encourage you when you're modeling your internship program to consider including both a fixed duration for the internship so that it's clear to the intern when it begins and when it ends, and also that the internship is not a segue or a training period for an actual job, and there's no job guaranteed at the end of the internship. That's another red flag where if someone is in a program for a finite period of time and they expect to graduate into your workforce, then it's sort of going away from an internship and more towards an apprentice-type program where they're entering the workforce as a regular employee. So again, the keys to consider when you're thinking about the internship program is, did the individual contemplate receiving any compensation for the work? And did the employer receive an immediate advantage from the work completed? Now, as I mentioned a little bit earlier, the Department of Labor draws a distinction between nonprofits and for-profit organizations. When it comes to nonprofit organizations, here's the general rule that you should follow, but consider the 6 factors that I laid out earlier. Unpaid internships in the private sector and in nonprofit charitable organizations where the intern volunteers without the expectation of compensation are generally permissible. So that's the baseline.
I think you meant public sector, right?
I'm sorry, what did I say?
Private.
Yeah, public sector, sorry. Again, that's the baseline that you're working from. Again, it's not in all cases, it's not going to be, you're not going to pass muster your internship program, but you should operate with those 6 factors I mentioned in mind and try not to depart from them too much. And this is another important consideration, is that an intern who receives academic credit from his or her educational institution for completion of the internship is much more likely to qualify as an intern. So to the extent that you can work with your interns and with colleges and universities, as it may be, to give them academic credit to approve of the educational opportunity in your workforce, the less likely you are to run afoul of the Department of Labor's policies. And here are just a couple of quick examples of situations when an intern would not be considered a trainee, but would more likely to be considered an employee of your workforce. First is if the intern, like I said, is substituting for a regular worker or is augmenting in some way your workforce. But for the intern, the employer would have hired additional employees. If you have an uptick in business and you really need to bring someone on, you can't substitute that person with an intern. And finally, the intern is engaged in the employer's routine operations and or the employer is dependent on the intern's work. What's good to know here is if you're, like I said, conveying tangible skills that the intern can take with them, that's more likely to fall within the training side of the ledger versus if they're really engaged in your day-to-day operations and are indispensable to your workforce, and they're more likely to fall on the employee side, excuse me. Okay, we're going to switch gears now to talk about travel time. Travel time is also synonymous with commuting time, and I'm sure everyone has a commute in the morning, some longer than others. This is just the general statutory language from the Portal to Portal Act, which established the Department of Labor's standard for commuting. The Portal to Portal Act exempts employers from compensating employees under the FLSA for or on account of time spent traveling to and from the actual place of performance of the principal activity. As a general rule, an employee who travels from home before his or her regular workday and returns to their home at the end of the workday is engaged in ordinary home-to-work travel, which is a normal incident of employment. This is the normal commute that you would go through every morning and every evening when you come home from work. And again, this is an important thing to think about because there's exceptions to the normal commute, right? I commute to Venable every morning and every evening, but another employee might not have a fixed work site, but they may have a work site which goes from place to place. If they're an individual who is engaged in training exercises or in presenting seminars, their work site may be a different school every week. It may be a different county or a different region of the country. And it's important to understand that there's not a cookie-cutter analysis for travel time to and from a work site. And that time that is spent commuting to that work site is non-compensable, whether it's fixed or whether it rotates from work site to work site. This is also true whether or not the employer agrees to pay for the commute. We've received questions about stipends that are given or metro check allocations that are given to employees. Simply because you as an employer are giving your employee some kind of commuting benefit does not convert that commute from non-compensable to compensable. So it's okay to provide a benefit for the commute for your employees. Normal home-to-work travel. So the key to determining whether the commuting time is compensable or not is to ascertain what is normal, okay? And that's not an easy answer always to arrive at. Unlike most legal standards where the court will look to sort of what is the regular person or the normal person, reasonable person going to do, when you're thinking about commuting time, it's not what the average American would do, it's what's normal in your employment relationship. So you have to look at it on a case-by-case basis and what your workforce is engaged in. So a couple of examples that I want to walk through quickly. This will illustrate a little bit what I just described. So if you travel from home to several on-site training workshops in different counties on different days in a given week, that would be a normal commute if that was what that employee, the understanding was with you when they signed up for this particular position. It doesn't change the analysis because there's a rotating work site. A farm worker who travels on a bus sometimes exceeds 2 hours the commute. I as an average person think that a commute of 2 hours is pretty significant and that you may want to compensate somebody for some of that commute. While if the normal commute for that employment relationship entails the farm, which is a rural farm far away from the employee's home, then that's going to be a normal commute in the context of that employment relationship. So that's going to be a non-compensable event. Another example is a construction employer with projects located at job sites that are an hour and a half, 1 to 1.5 hours from the home office. Again, it doesn't change the analysis if the work site changes, depending on what your employment relationship is. And the last one is one just to kind of, there's a question, yes?
Hi, yes. Regarding the construction worker, if they have to check in at the home office and then go to a work site, that one is considered?
So if the question was if there's a construction employee who needs to check into a home office and then goes out to different work sites throughout the day. And we're going to get to that in a minute, but the short answer is that the commute from the employee's home to the work site, to the home office rather, would be commuting time, non-compensable, and then every other travel after that would be part of the normal workday, and that would be compensable time. And the last example is a little bit of an extreme one. If an employee's commute to the first job site in the morning takes 4 hours, and this is from a recent case. This is a pretty extreme example, and you wouldn't be able to write off those 4 hours as non-compensable commuting time, unfortunately. Okay, working from home. This came up a little bit earlier, and there's a small wrinkle when it comes to travel time. Employees who work from home, and that is, again, is when you have your personal office or your main work site is your home, you may be compensated for commuting time. That's because there is no commute for you because you're working from home. So the example from a recent court case was when an automobile damage appraiser who had their home office at their home had to go out to different work sites to examine automobiles. That travel to those different sites would be compensable because that's not a commute. That's part of the employee's daily activities. Home to work in an emergency situation. This is instances when the travel from home to work would be considered compensable. So this would be outside the normal working hours of an employee. Let's say that there's one designated non-exempt employee in your workforce who has to answer, let's say the fire alarm goes off at your work site, and there's one designated employee who needs to go meet the fire department just to make sure that everything checks out. If it's 2 o'clock in the morning, that commute from that employee's home to the work site, even though it's the normal commute they would normally go through, because it's emergency and it's off hours, that would be compensable time. This is another common occurrence that we see, which is home to work on special one-day assignments in another city. And this begins to touch on the question that the gentleman asked earlier, where if you have a fixed work site and you're now given an assignment that takes you away from that home work site on a particular assignment for one day to another city. Employee travel time that is not part of the employee's ordinary commute is compensable time. So bear with me as we walk through this example because I think it illustrates the complication that can arise and also how you really need to pay attention to documenting the hours of your non-exempt employees when they travel. So an employee works in Washington, D.C. with the regular working hours from 9 to 5 and is given a special assignment in New York City with instructions to leave Washington at 8 a.m. That employee arrives in New York at noon ready to work. The special assignment is completed at 3 p.m. and the employee arrives back in Washington at 7 p.m. The travel is not ordinary home-to-work travel, okay? Clearly it's not ordinary home-to-work travel. The employer, you can't argue that the employee in this scenario had an uncompensated 4-hour commute to New York. Just because they weren't working and they arrived in New York ready to work, you can't write off those 4 previous hours as a commute to New York. But you may look at the travel of that employee from that employee's home to the railroad depot may be deducted as compensable time. But then the clock starts because just because the travel is during the normal working hours, it cuts across the employer's normal work schedule, the normal work day. So just because it's travel does not make it non-compensable because it cuts across the normal working hours. This is another topic that we touched on a minute earlier in the question, which is travel that is part of an employee's typical workday. Time spent by the employee in travel as part of the principal activity, such as travel from job site to job site during the workday, must be counted as hours worked. So that answers your question more clearly. Where an employee is required to report at a meeting place to receive instructions or to perform other work there, the travel from the designated place to the workplace is part of the day's work. And the example here, and this is an informal arrangement that a lot of employers have, is they'll ask a non-exempt employee, oh, can you stop at so-and-so's house on the way home and drop off this PowerPoint or drop off this presentation for the next day? Well, if that's at the instruction of a supervisor or a manager, that's not the employee's own time. They're now under the direction of the employer, so you need to compensate that employee for that time that is traveling to the coworker's house to drop off the PowerPoint. So just be aware of the instructions that you're giving folks throughout the day and also what the expectation is that you're placing on your workforce. Yes?
Let's say the normal time home here to their home is an hour, and that they're dropping something off 10 minutes from their house. So 50 minutes to that other place, then 10 more minutes to their house. Are you saying that 50 minutes is compensable?
Yeah, I mean, the question was if there's an hour-long commute for the employee on a regular commute home, and the coworker's house is 50 minutes from the work site, and then there's only about another 10 minutes between the coworker's house and that employee getting home. The question was, is the first 50 minutes a compensable activity? And it's not an easy, clear-cut answer. I would say that to err on the side of caution, and you would probably want to compensate that employee for that 50 minutes because you've instructed them to drop something off, so that's not their time that they can do as they please, but it's time that they need to follow your instructions during. So I would say that 50 minutes would need to be compensated in that situation.
And pay close attention to the next section because this is where we get a ton of questions from our nonprofit and association clients in areas that this is probably one of the most confusing areas of this whole presentation.
Yes, and I will do my best to make clear, and please, if you don't understand, feel free to ask questions, and I can backtrack because it is, as Jeff said, a very common area of inquiry that we do get. Travel away from home. Travel that keeps an employee away from home overnight is considered travel away from home. Travel away from home is compensable time when it cuts across an employee's workday. So again, an employee that is simply substituting travel for other duties, you still need to compensate for them. You need to compensate them for that time. So let's look at this example here. If an employee regularly works from 9 a.m. to 5 p.m., Monday through Friday, the travel time during these hours is work time on a Saturday and Sunday as well as other days as well. So let's take an example of a conference that maybe might span from Sunday through Tuesday. The employee's work hours from 9 to 5 on a Sunday need to be compensated in the same way that they would be on a Monday or Tuesday if they're traveling away from home. And Grace talked a little bit about the regular meal period, and that's going to be applicable no matter what day of the week that meal is taken. The Department of Labor has said that it will not consider as working time the time spent in travel away from home outside of regular working hours as a passenger on an airplane, train, boat, bus, or automobile. So what does that mean? Well, if an employee normally works from 9 to 5 and a flight leaves at 5 p.m. from Washington, D.C. to a conference in New York, and then that employee, when they arrive at LaGuardia, will be taking a cab to the hotel from the airport, the 2 hours or so that that trip likely will entail is not counted as working time because that travel time is outside of the employee's normal working hours, and they're a passenger. They're essentially they're not working, they're a passenger during that flight time. So that's not a time that you need to compensate them. However, let's say the flight left at noon and arrived in New York at 1, and then the cab took them to the hotel. Because that travel time is during the normal working hours, you still need to compensate them for that time. Everyone can nod if you agree? Okay, good. Yes, question?
What is your ask as an employee and you're on the flight from 9 to say 7 if you're actually doing work on that flight? You're preempted my next slide, but we will cover that. And I just want to touch on this last point because it's actually very important. If an employee is offered public transportation but requests permission to drive his or her car instead, the employer may count as hours worked either the time spent driving the car or the time it would have counted as hours worked during the working hours if the employee had used public mode of transportation. So what does that mean? Well, some employees may have a fear of flying or a fear of taking a train, so that employee may say, well, I want to drive to New York instead of taking the flight and the cab. Well, you have an option at that point. If you're going to grant that employee the ability to drive, let's say the drive takes 4 hours, and I think that's what it takes to drive to New York. You can choose the lesser of the time period of the drive that it would take or of the flight and the cab as compensable time. So that's at the discretion of the employer.
And Rob, what happens if it's a situation where there's a meeting down in Richmond and you require the employee has a car, you require them to drive because it's the most efficient way to get down there or something, we've had situations where we've had to go to some remote areas where there's no easy mode of public transportation. If you require someone to drive, how do these rules apply, in terms of the working hours versus non-working hours?
Well, the short answer is that if the drive is during the normal working hours, then it would be a compensable activity. So if the employee is working from 9 to 5, and the employee leaves at 9 from the home office and is asked to attend a convention in Richmond and give a presentation, if it's 2 or 3 hours to Richmond, that would be compensable time, that drive down to Richmond. Yes?
So are you saying that an employee works 9 to 5 today and then they have to be in New York at 9 tomorrow, that if they're at work from 9 to 5 today and they report at 9 o'clock tomorrow, that the getting there is non-compensable?
Yes, if they are a passenger on the mode of transportation that I went through, passenger on an airplane, train, boat, or bus or automobile, yes.
But if they drove to New York from D.C. after working hours, and not choosing to drive but required to drive,
right.
You addressed the example if they choose to drive when public transportation was offered.
So if they're required to drive, then you need to compensate them for it, but you can choose the lesser time period of the drive or how long it would have taken if they had taken public transportation. Work performed while traveling, and this is your question, and it's also a little bit of a modification of what Grace alluded to earlier. I think she was talking about it in the context of working from home, and this pertains to work that's performed while traveling. So any work which an employee is required to perform while traveling must be counted as hours worked. It's a pretty clear-cut rule that you have there. Time spent by an employee writing a report is work time, whether or not it happens when they're riding a bus or they're sitting at their desk. So, you need to be very cognizant when you're giving work assignments out to instruct your employees when they should be working on it and when they shouldn't be working on it. Some employees may think, if I don't finish my report by the time I leave and that my boss needs it by tomorrow, I'm just going to do it while I'm riding home on the bus. Well, they may choose to do that, and you need to compensate them for that time if the expectation is that they have it ready the next morning. The time spent working on a commute must be more than a de minimis amount in order to be compensable. And the de minimis threshold is a little bit of a fuzzy standard, and it's going to be really analyzed on a case-by-case basis. But here are a few examples that I hope will illustrate for you guys what a de minimis means. Law enforcement officers that are required to monitor radios during their commute. So this is a passive, more or less a passive activity. When they're driving to and from their home, they have to listen to the radio. Well, that's not a huge commitment on their part, so that would be a de minimis amount of work that would need to be performed. The second example is a fire alarm inspector that's required to carry a briefcase with safety documents during a commute. Well, they're carrying a briefcase anyways. They may have their book that they're reading during their commute in it. Just because it has safety documents that the employer has asked them to carry doesn't convert that to a compensable activity. And then here's the third, but very important, but also commonly a pitfall for nonprofits is an employee that's required to carry a work-issued BlackBerry with him or her home every night. It's not a compensable activity merely because you say you need to have your BlackBerry with you in case there's an emergency, in case we need to contact you. But if that employee is expected to read a PowerPoint presentation on their PDA, or it needs to write a report or respond to emails while they're commuting, then that's going to be a compensable activity. So be very cautious when you're issuing work BlackBerries to your folks to instruct your employees in your workforce what is an acceptable use of that device outside of their normal working hours. It's important to put those policies in place at the beginning so that there's no confusion about how they may use it and when they may use it.
So just to stress, this is a really important point, kind of a proactive planning point, that when you have non-exempt employees who are traveling in connection with work, if you do not want to compensate them, say they're traveling in off hours and you don't want to compensate them for the travel time, be sure to instruct them that even though it may be an otherwise worthwhile activity to spend the time preparing for the conference that they're traveling to while on the plane or the train, that they are not authorized or permitted to do so. So if they choose to do it on their own, that's up to them, obviously, but you're not permitting or instructing or suffering, these are words that the Fair Labor Standards Act uses, to allow them to do that work. You need to be very clear in your instructions.
And I just want to quickly touch on travel time and company-owned vehicles. I'm not sure how many of you have company vehicles that you issue to your workforce, but just be aware that there's a Employee Commuting Flexibility Act that was enacted in 1996. When an employee has the use of a company vehicle for normal travel between their home and work and stops either to change the oil or to get the car washed, that's not considered compensable time. But this is something that we caution our clients all the time about. In this situation, it's really a best practice for you to reach a formal usage agreement before you issue that vehicle to them so that they know what's an acceptable use of it, when's an acceptable time to use it. Yes, question.
Back to the shift. So if you travel after hours, meaning tell the employee, don't expect you to work complain about it, and if they're working from home and you don't authorize it, like get an email.
Yeah, Rob, can you distinguish, Mary's question is, if you have instructed them not to work, but then you later find out that they did work on that flight or the train from D.C. to New York, are you then obligated to compensate them, or do you risk yourself getting in trouble? And distinguishing that from the earlier example we were talking about was where you didn't instruct the employee at all what to do or not to do. You just allowed them to do it, and you found out, or you didn't intend to allow them, but you found out about it afterward. That is compensable. But here, if you expressly instructed them not to, and they did anyway, and Grace kind of touched on this earlier, but why don't you give your take on that?
Yeah, it's a really hard question. Grace, if you have a particular thought on it, my view of it is it's not an easy answer, and if you have a policy in place and you've given pretty clear instructions that they shouldn't work and they still do, you have to weigh the risk. You don't necessarily need to compensate them for that time, but you may be opening yourself up to risk if you don't compensate them. And then they show, look at this work product that I produced during my plane ride. I wrote this report after working hours. So you have to weigh the risk. I don't think there's a perfectly clear answer.
And you certainly want to make sure that you couple that with some sort of disciplinary action after the fact. So even if you decide to compensate for them for that particular segment of time, say, we're going to pay you for this, but this better not happen again. This was against our instructions. This is just like any other disobeying of an order from your supervisor, and that has adverse consequences.
That's an excellent point, and I think that's the appropriate approach that I would counsel everyone to take. As I said, for the Employee Commuting Flexibility Act, we advise employers just to develop beforehand an understanding and a usage policy for the vehicle. If the employee has traveled outside of the normal commuting area for work, the time spent beyond the normal commuting distance is compensable. Inclement weather, which is something also that we touched on a little bit earlier, so I'm just going to breeze through it pretty quickly. Under the Fair Labor Standards Act, which we've stated over and over again, non-exempt employees who do not report to work due to inclement weather, shutdown, do not have to be paid for that day. They're hourly workers. They're paid for the time that they work. If they don't get into work that day and they're not performing any work, and you haven't instructed them to perform any work, then you don't need to compensate them merely because your office is closed. If a non-exempt employee is late for work due to inclement weather, but the employer is open, the employer also does not have to pay the employee for time not worked. Again, it's fairly straightforward. If you've instructed them to do work or to be somewhere, then you need to compensate them for that time, and if they have not been instructed to work, then they do not need to be compensated.
You know, Rob, it looks like we, on the webinar component, because we're scheduled to stop at 2, looks like the webinar part has, the slides have gone off for those on the phone. For those of you who have dialed in on the phone, you should still be able to hear the audio for the balance, but unfortunately the slides are not available. They were emailed out to everyone as a link to the confirmation email that you received, so you can click on that and kind of follow along on your own, but we apologize for that. We'll fix that next time around. And as Jeff stated at the outset, this seminar is really focused on non-exempt employees, but we just want to explain the distinction between non-exempt and exempt employees when it comes to inclement weather. If a shutdown is for less than a week, exempt employees still get paid for that entire work week. If the shutdown for an entire week is due to inclement weather or other emergency, the employer can technically dock the full week's pay, but should consider employee relations problems. And again, that's going to be up to the employer whether they think it's wise, sort of a morale issue for the workforce to dock that entire week's pay from their exempt employee. The employers may be able to require exempt employees to use paid time off, and Grace alluded to that earlier in her presentation. State laws are very important in this area, and I would, some of you may be located in D.C., others elsewhere, but consider what the state requires for your paid time off in your workforce. Some states do not allow employers to require the use of paid time off during inclement weather, and some states require a report and pay for non-exempt employees, and D.C. is a great example of that. Non-exempt employees who report to work for their regular schedule but are sent home get paid for the lesser of 4 hours of what their that actually word should be, it's a typo, I apologize, for the lesser of 4 hours or what their regular schedule would have been. Let me translate that for you. If an employee reports to work and after an hour they're sent home because of inclement weather, you need to pay them for that 4 hours under D.C. law. So it's, yeah. Okay, is everyone clear on that? Nod your head yes. Good. A couple of residual issues that I'll just touch on briefly. One is receiving medical attention. This is sort of an anomaly, but it does occur sometimes in the workplace. If you have a nurse's station or another first aid area and you've instructed an employee to seek medical attention, or they need to go there on their own to get some kind of medical treatment, the time spent waiting and receiving medical attention on your premises still needs to be compensated. So that's not a non-compensable event. Also, a lot of employers have suggestion systems, and these can fulfill everything from improving your workplace to getting buy-in from your employees if you want to get their feedback. There's a little bit of a distinction here that I would encourage everyone to keep in mind. One is time spent outside of the work developing suggestions under a general suggestion system is not working time. So if you have a general policy, we accept suggestions from all of our workforce. Someone goes home and writes a journal entry about how they think the workplace can be improved. They come to work and they drop it in the suggestion box. Well, the time they spend at home, drafting that entry is not compensable time.
But if the employees are permitted to work on the suggestions during their regular working hours, then it must be counted as hours worked. And this is another small caveat. If the employee is assigned to work on the development of the suggestion system, then the time is considered hours that need to be compensated. Forced shutdowns and furloughs. During a down economy, a lot of employers have resorted to furloughs. Sometimes business requires a forced shutdown to occur. And one question we get all the time is it legal for an employer to reduce the wages or number of hours of an hourly non-exempt employee through a furlough? So all non-exempt employees must receive at least the minimum wage for all hours worked and overtime pay at time and a half for hours that are worked over 40 in a work week. And that's the standard whether or not you have a furlough or a forced shutdown. The Fair Labor Standards Act does not preclude you from lowering in any way the hourly rate or the number of hours worked as long as you're remaining consistent with overtime, minimum wage and overtime laws. So you can have a forced shutdown, you can have a furlough and reduce the hours of a non-exempt employee at your discretion. Another question we get is, does an employer need to pay an hourly employee for a full day of work if he or she is scheduled for that full day but only works a half a day because of lack of work? And the answer is that the FLSA does not require you to pay non-exempt employees for the hours that they do not come to work.
Do you want to, Rob, just talk for a second? And by the way, the slides are advancing fine for the folks on the phone. Now we fixed that. You want to address the issue of kind of the pay docking rule, the issue of if you dock a non-exempt employee for less than a full day's pay, how that can have the potential effect of converting them to an exempt employee. You or Grace, I don't know who's most fluent in that issue.
Well, for an exempt employee, you want to treat them as exempt. Can everyone hear? Am I on? Exempt employees have to be paid on a salary basis, as you all know, and that means that for every given week, no matter how many hours they work, whether it's 30 or 60, they get paid the same salary every week. That's a requirement. If you start treating an exempt employee like a non-exempt employee, that could hurt that salary basis requirement. So, for example, if you dock the pay of an exempt employee in less than full day increments, then that could start looking like you're treating like an hourly employee. So if they work half a day and you dock 4 hours from their pay because at the end of the week they haven't made that up, suddenly it starts looking like they're non-exempt and you're looking at the hours that they're working rather than just saying, hey, you get this salary every week no matter what. That could really damage the salary basis requirement for exempt employees. The only exception to that, well, there's a few, but the main one is that if you're docking, if someone is on, legitimate FMLA leave, if, you've got the medical certification and it's, you've got the records and everything, then you can dock from an exempt employee in hourly increments without, running the risk of damaging their exempt status, but that is a very limited exception. So the risk of doing that, of course, is, it may not just affect that employee, but it could affect other employees in that classification. So if one person is deemed as non-exempt and you're treating other employees that way too, that could affect, other people in that same job classification.
Thanks. That was perfect. I had stated the question the opposite. Yeah, it's the risk of converting an exempt employee into a non-exempt employee and having to pay them overtime.
Right.
Okay, and we're on to our last slide, and this is a little bit outside the focus of the presentation, but I think it's an important note to end on because again, this is the impetus is on the employer to really keep very accurate and robust time records. You do bear the burden of keeping records of an employee's hours worked and the pay that you give them. Non-exempt employees should be required to record all time, vacation time, comp time, paid time off. You really want to have a very stringent document timekeeping system so that there's, in the unlikely scenario that you do face litigation or that you are under scrutiny from the Department of Labor, if you have very tight books and you can point to the time records with accuracy, it's really going to help you minimize the risk of liability down the road. And again, Grace touched on this, supervisors should be required to approve all time records. So if an employee is in charge of keeping his or her own timesheet, you need to make sure that the supervisor is scrutinizing that document and signing off on it. Yes, we have a question.
What's the statute of limitations for these hour claims? Like how long should the employer keep the record? How many years?
Yeah, so the question was, what's the statute of limitations for Fair Labor Standards Act claims? It's 2 years and it's 3 years for a willful violation of the Fair Labor Standards Act. It may behoove you to actually keep records for longer than that, because there may be other laws that have other time requirements for record keeping. So make sure you look at what the state laws are in your area and other statutes as well.
We have a couple related questions here, and I know we've gone over the time, but virtually no one has left the room and virtually no one has dropped off the phone, so it seems like there's a high interest. So we're going to go about another 10 minutes to wrap this up. And Grace, this is probably a question for you, a follow-up to the last issue you addressed. Outside of kind of true FMLA, Family Medical Leave Act leave, if an exempt employee has to go to a 2-hour, personal appointment, doctor appointment, any kind of personal appointment during the workday, can you require them to take 2 hours of sick leave or vacation leave for that particular day without risking turning them into a non-exempt employee?
Sure, that's a little bit different than docking their pay. So you can require exempt employees, pursuant to your policies, to use their sick time if they are, gone for 2 hours for a personal doctor's appointment, and that should be spelled out in your policies. You can dock from their sort of PTO bank in hourly increments without damaging the salary requirement for exempt employees, but you don't want to start docking their actual salary in hourly increments for these absences.
Okay, and Rob, this question is for you. What about requiring exempt employees to track their time and keep time records? Obviously there are many other laws that apply to nonprofits, lobbying-related laws and federal grants and contracts and other laws where exempt employees are required to keep time records. But outside of those particular requirements for employment and labor purposes, is there a risk of requiring exempt employees to keep track of their time? Does that in any way pose a risk to their exempt status?
I don't think that there's anything that says, hey, you can't say to your exempt employees, track your time, especially if, in fact, you have a justification, for other reasons. You want to know how long they're spending on different issues. It's actually not a bad idea in some ways, although the only risk I can think of is, let's say that exempt employee is actually not exempt, and it turns out that they're not exempt and you should have been paying them overtime. On the one hand, you have the records to show, hey, you weren't working 10 hours of overtime every week. It was actually 5. Here are your time records, and now you've limited the amount of back pay. On the other hand, if it was an exorbitant amount of overtime that they were working and you never said, not to work that time or limited the amount of time, then you will be held, in terms of calculating back pay to paying for that time.
Okay, one final question, and then we'll let Rob wrap up. For an exempt employee, I assume that the answer for a non-exempt employee would be fairly simple. So this is an example where someone's a volunteer firefighter or a volunteer, emergency medical technician. They get the alarm, they get the call, they need to go off to duty. Presumably, for a non-exempt employee, you don't have to pay them, for the time once they leave and go off to do their volunteer duties. But for an exempt employee, you want to address kind of that same issue of can you require them to use leave? Can you dock their pay for the hours that they leave early that day, et cetera?
Again, in general, an exempt employee must be paid the same salary every week, regardless of whether they work, even if they leave early for an emergency situation at home or for their volunteer firefighting responsibilities, they get called to duty. For the volunteering, it's a good idea to think about that ahead of time, maybe put some policies in place in terms of whether or not you're going to require them to use some kind of PTO for that time. But that's going to be an internal policy, and you should look at how you want to address that and think about sort of your culture and morale and how much you want to encourage people to volunteer outside of work.
Okay. Rob, you want to advance to the last slide? I had asked Grace and Rob to put together this chart, which I think you'll be really pleased with. You can actually use it as a test if you want to see how well you did in today's program. Cover up the right-hand column. And these are questions about 10 different kind of very common hypotheticals in the nonprofit world, and in these 10 examples, whether the time is compensable or not. We're running out of time here, so I'm not sure we're going to go through, why don't we skip kind of walking through them. You have them in your PowerPoint materials. You can go through them. You can test yourselves. We'll also post this as a separate standalone document on our website, so I think it's a very helpful document. But it highlights, I think, a lot of the key issues that we focused on today. Rob, do you have anything else?
That's it.
All right, let's open it up for just a few questions, and then we've got to wrap up. Yeah, in the middle here.
Okay, so going back to drive, somebody has a 4-hour drive, let's say 5 to 9 o'clock. The driver at that point is off duty, but he's away from home, he can't conduct his personal business. What hours does the driver have to be compensated for? The next day, he has to drive the executive back. Let's say during work hours, so that's not a problem. But in the meantime, he's working overnight. Do you have to pay him for sleeping in the hotel?
No, I mean, the answer is that.
Can you repeat the question?
Oh, I'm sorry. The question was, if you have a driver who is driving an executive from 5 p.m. to 9 p.m., and he or she is away from home, must you compensate them because they're sleeping away from home from 9 p.m. until the next day when they have to drive the executive back? The answer is, starting at 9 p.m., you don't have to compensate them. The time is their own. Even though they're not at home, they can do as they please. They can call their spouse. They can go out for a beer. They can, go to dinner, whatever they want to do after 9 p.m. As long as the time is their own, you don't need to compensate them for it.
All right, why don't we take one final question in the back, and then we're going to wrap up.
I have a question about kind of comp time for typically the 40 hours in the first week, second week they work more than 40. Can you use that time and a half for the shorter than 40?
So the question is for comp time, if it's a 2-week pay period and they work less than 40 hours in the first week and then they work, a lot of hours in the second week, can that still be used as comp time? And that would really require some forward thinking, planning ahead. So if you know, for example, that in week 2 of the pay period of your conference, they're going to be working 60 hours, you could give them time off in the week before that at time and a half of their overtime, of the overtime hours, and say, hey, because of that, the week before you're not going to work your full regular shift, you're only going to work X number of hours. But logistically, it might be challenging if there's a lot of work to do leading up to the conference. So that's not something that we see a lot, but it's technically possible.
Yeah, that was a great question. All right, well, I want to thank our speakers, Rob and Grace, for a really terrific job. This is complicated stuff. I think they helped to simplify it in a lot of ways. We really thank everyone for their participation here in D.C. and on the telephone today. And keep a lookout for our next seminars and webinars. Thank you very much. Have a good afternoon.
Thank you. Please stand by.